want to make the most of our time. So first I'm going to introduce John Howe, Howe and Hutton, Chicago, Illinois, co-chair with Rod Abraham of the ISBO Advisory Board. And he might be a lawyer too. I'm pretty sure that might be true. If you don't know John, then I seriously wonder why you're here. So John, say hi to everybody.
Good morning, everybody from Chicago. It's really not Mars. I apologize for the greenish, but we've been trying to correct that about the last hour, and for some reason, it's just not cooperating. So I would be happy to welcome anybody's suggestions after we're done with this as how to get back to Technicolor as opposed to a greenish black background. I think what Josh and I are going to talk about this morning is what you want to talk about, not what we think you want to talk about.
So our other presenter is Josh Grimes, another lawyer whose name you should know if you're in this industry. And just like John, Josh is a prolific author in our industry publications, does presentations. And I want to say that both of these very well-known and overworked attorneys right now, and I say that with all sincerity because they're probably working 20-hour days right now. With all the contracts and such with their clients and with the demands on their time. They are doing this for you free of charge. So a big shout out to both of them for doing this and for being with us on this, what I consider to be very important. We have been hounding industry associations to recognize independents and small business owners for a long time. If you're not a member of the ISBO community, please join. We need your help. We need your numbers. We need your strength to make us a very viable community within MPI. And that would be our only request of you. With that, Josh has his law firm in Pennsylvania. And Josh, would you say a few words and then we'll get going?
Okay, thanks. And Marianne, thank you, and to John and to Rod Abraham for putting this together and having me participate. Now, I had about 2 pages of comments prepared, but after John's so efficient initial presentation, I'm going to throw that out so we can get to everybody's comments. But let me just say this. I think we all recognize that we're going through this challenging time together and that we're going to get through it together. When I say we, I mean planners, attorneys, suppliers, vendors, venues, and everybody else. I think what's clear is that to move forward, planners in particular are going to be called on to deal with, to show their expertise in this challenging time. I mean, before we started this session, Marianne and I were just talking about, we don't know what's 3 months in front of us, 6 months in front of us, or a year in front of us. We don't know what conditions are going to be to have a meeting, what social distancing and other requirements are going to be. Can we do buffets? Can we do networking events? What do we put in our contracts to deal with that? And I think that planners with experience and with background in doing previous events, but also those who get education and sort of learn what best practices are going forward in terms of health and contracting and safety are going to be the ones who distinguish themselves and become more valuable as we go forward in the future. So having said all that, I'm going to trash my speech and I'll prove I actually did have it. And why don't we get to what everybody wants to talk about?
Okay, can one of you, either John or Josh, please do the necessary, you're not their lawyer's speech, please?
Oh yeah, I'll be happy to. Obviously, as Marianne suggested, this is a pro bono by Josh and myself. The one caveat always is we're not rendering legal advice, and even if we were, remember that it's worth the money you're paying for it. And we don't create any kind of attorney-client relationship by doing a program like this. I'd like to also say, echo a little bit of what Josh was saying, but you know, we keep hearing this term, the new norm. Well, let me tell you folks, we aren't going back to a norm. we're going to a new reality. And how we've done business in the past is not how we're going to do business beginning tomorrow, or for that matter, even later this afternoon. We are in a great state of flux. The successful person who's going to get through this, I'll go back to 1990 when we were going through a recession of a kind, and the hotel industry was in a great deal of panic. Darrell Hartley Leonard, who at that time was chair of the board or president of Hyatt Hotels, had a great line. He said, "We've got to survive to 95. Well, perhaps the logo this year is, "We've got to survive to 2025. And it may take us that long to get back into a pace in which we can realistically do business, provide a product, provide that basic human need of bringing people together. How we bring them together and under what circumstances, it's going to be a different world. And it's going to be something that none of us have ever experienced before in our lives. We already are experiencing that. And so as to what's hot and what's not, Mary Ann, let's go for the questions.
Sounds great. Let's say the first question I see here is from Connie Bergeron. Hi, Connie. How you doing?
Good morning, Connie.
Hi, Connie.
I have classified these. Hers deals with third-party liability on cancellation clauses. What is the legal responsibility for third parties who edit venue contracts for clients and whose force majeure excuse for performance clauses have exposed their clients to cancellation damages due to contracts being poorly worded? I can answer it. Run.
John,
Go
do you
ahead.
want to go first?
Sure, I'll take.
Which off?
A lot of you know my definition of a contract. It's relatively simple. It's a self-inflicted wound. And so we look constantly at what the terminology of the contract is going to say. We've got a lot of people running around saying, I have a force majeure contract clause. It states blah, 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 if it makes performance impossible or illegal. Well, you have two things you have to factor into when you're evaluating that clause. Number one is, yeah, this is a force majeure, but number two, does it make it impossible or illegal to perform? And so many of these clauses, that is a very open question depending upon what the venue is and the rest of it is going to be. We have client contracts between the third party, the client, and let's say the property, the venue, or the vendor. And unfortunately, many of them have cancellation clauses, if they have them, which do not track with each other. And so that causes a bit of confusion overall of trying to figure out what is going to happen, when it's going to happen, and to whom it's going to happen. So I look at this in a way that says that if you are a third party, you're a small business owner, independent, you've got to look at the contract you have with your client as to what rights you have in the event of cancellation versus what rights the hotel has or the client has in canceling out the vendor. Two entirely different things. But from the standpoint of your client contract, what have you put in that to protect yourself to be compensated in the event of a cancellation for the work that you have performed to date? If it's solely based on commission, well, if you don't get a commission, you're not going to be compensated. So I think what you have to look at is, what is your fee structure? How do you protect yourself at the same time you're protecting the client? None of us like to work for nothing. We do it, unfortunately, and it's become self-imposed because of that self-inflicted wound that we placed upon ourselves when we entered into the contract and did not think through the whole effect, the whole running effect, and the aspect of what a cancellation would mean. Might mean no cancellation or no compensation with the hotel, but what does your client contract provide relative to your compensation there?
Josh, anything to add?
Sure. Let me just add some things to John's really pretty thorough answer there. In terms of liability of the third-party planner, first, it's important to make sure that you're clear about what we call your agency in the contract. are you signing contracts? First of all, is the client signing the venue contract, or are you as a third-party planner signing it? And if you're signing it, is it clear that you're doing it as the agent of your client? So that needs to be clear. Also, in terms of liability, of course, everyone should have insurance, including errors and omissions insurance. And I'm not suggesting, these days, force majeure clauses are changing so much that I don't know that you could ever point out that someone made a mistake. But you should always have insurance. And I also suggest with a third-party planner that you consider capping your liability. Sometimes we see that in your contracts with clients to say that your liability will not exceed the amount of your insurance or the amount that you're being paid for your services or something like that. But you should consider a cap if you're able to negotiate that with your clients. Thanks.
So we have a comment from someone which I think is worth having one or both of you comment on. Bob Kapowski, pardon me. Third parties should not be negotiating terms or giving legal advice for these terms. Facilitate communication between venue and end user, absolutely. Giving suggestions, not so much.
There's a fine line here, and I have seen it on a couple of instances as to where a third party has been accused of the unauthorized practice of law for that very reason of providing and filling out contract terms, et cetera, et cetera. Not too far distant from what has happened in the real estate industry over the years, where real estate brokers and agents will basically go to their customer, their client, the buyer or the seller, and say, here, let me give you the contract. Here are all the things you need to know. I'm going to advise you on whether it should be taken in joint tenancy or whatever. And almost, I think every state now has what they call a lawyer-broker accord, which deals specifically with the unauthorized practice of law, what can be done and what cannot be done. In our arena where we're playing today, we don't have such a thing as an accord. One of the key concerns is you're always better off going, and this will be our plug, Josh, for the bar. You're always better off having an attorney review and make those suggestions to avoid that kind of liability. Because I don't think I've seen it yet, but I can guarantee you that it's going to happen, is that somebody who is a client of a third party is going to become very unhappy with the services provided. They will find an attorney who was enterprising and say, wait a second, what that third party was doing was the unauthorized practice of law. We've got something there. Plus, the advice they gave you was crummy, or the contract they gave you was bad, or it set you up for a liability that you had not anticipated. The key element here is you've got to protect the interests of all. Josh made the comment about agency. And the question when you're taking a commission is, are you the agent of the vendor, or are you an agent of the client that you represent in those negotiations and trying to achieve a result that's going to be worthwhile and successful for both sides?
So I'm going to ask you both a question. I don't really care who answers it. Is there a right time to cancel or move a meeting? I mean, let me rephrase that. Is timing important?
Can I start with that one? I think, and I guess is the implication here is that this is under current conditions, meaning cancellation due to COVID-19, and I'm going to answer based on that's my assumption. It depends on what the goals of your client and also what's in your contract. The one thing that I have learned, actually I've learned a lot of things, but one of the things I've learned in the last 8 weeks or so, or it seems like we've been doing this longer, is the applicability of force majeure clauses and how to successfully invoke them. And one thing that has become apparent is that if a dispute were ever to go to court, that courts tend to narrowly construe force majeure clauses, and they look at whether the conditions in the clause that allow cancellation without liability by both parties are actually there. So if you're looking to cancel a contract that is at the end of May, we probably have a very good idea of what conditions will be at May. But if your meeting's in October, when we don't know whether properties will be open and in what conditions they can be providing services, it's much more less of a certain issue. And I think it would be harder to cancel for force majeure. So then you have other considerations. These are meeting contracts. I would argue that the time of exercising a force majeure, unfortunately, in most of our current contracts, it isn't clear as to when you do that. If you're representing a meeting group, you would say, well, our attendees have to book their flights, have to book the hotel. So if our meeting is in September 15th, we can't wait till September 10th to cancel. We need to know July 1st because people have to make their arrangements. Contracts aren't clear about when these determinations are made. I would argue that you could make a force majeure a determination when your people need to book, would otherwise be booking their arrangements to attend, but not clear. This is something going forward. I'm recommending that people incorporate in their force majeure clauses a date by which a group can make a determination. If you're looking to cancel for a different reason, of course, you can cancel whenever it's convenient, understanding that cancellation damages tend to escalate. What I recommend, and then I'll turn it over to John, is that if a property is not agreeing that it's a force majeure, you might as well, if you can, wait. If your damages are not escalating under the worst of circumstances on your regular cancellation clause, and then see what happens going until you get to the date where your damages might escalate, and then reconsider at that point what conditions are.
Just taking a little bit further what Josh was saying, one of the key things you need to do is pull all of your contracts out and see what the provisions are within them. Do a spreadsheet. And what you want to plan on is what is the worst possible case that has to happen before you have to pull the plug. For example, if you were having a trade show and you were having exhibitors from outside the United States who needed to bring their booths in or the rest, you might need to cancel 3 months out just for them to be able to facilitate the delivery of the product that they want to deliver at the trade show. On the other hand, if you got a board meeting of 50, 60 people or whatever, and you look at what the schedule is, you go into the contract and you play the waiting game. What we've seen here, under the circumstances, we've seen too many games of who's going to go to the cliff and blink first. And and I'm sure Josh has too, several cases in which the meeting planner pulled the plug because that was their drop dead date. They had to pull it. And then 2 days later, the hotel was prevented from being able to perform because of orders of the governor or whomever. And the hotel comes back and says, oh, well, you canceled before there was a force majeure. You've got to make your decision on what is in the best business interest of all concerned and from a pragmatic standpoint. And sure, as long as you can delay it under these circumstances, you may want to play that game. But on the other hand, today we see that you may have a meeting that's in, let's say, June 30, but for that particular state or locality, June 15 is when they'll have a review date by the state. So you may have to make that decision on June 10, but you got to make that decision based upon what you have and what you know at that time from a business point of view as well as the legal point of view. But here in so many situations, don't let the legal dog wag the tail. You got to look at what you have to do for not only the interests of your participants, your employees, the employees of the facility, but what's going to be in the best interest of the brand.
Right. If I might add just one other thing, because I think this is a really important question. Cancellation for force majeure is usually a two-way street. And we tend to talk about, by nature of this forum, about the clients not being able to perform. People don't want to go to the meetings. It's also important to consider whether the venue can put on the meeting. So if you're creating, unless the venue agrees with you that it's a force majeure cancellation, you should consider creating a record of what their conditions are. So if I have a meeting in 2 weeks, maybe it's possible the governor might open it up and let them have a meeting, but the hotel may have furloughed all their employees. They might be closed now or open, but with very little occupancy. The restaurants may be closed. The bar may be closed. The athletic facilities may be closed. So those are all things that if the hotel's unable to perform, it argues for a force majeure cancellation based on their ability. So the point is, create a record of the conditions, because to the extent there's not agreement, it helps to see everybody's ability to perform.
One other thing, as to that too, that ties in, is going to the hotel and saying, well, you're asking me to be sure I can perform. Are you prepared to give me an assurance that you will perform, and that should you not be able to, will you pay me the cancellation fee that would be due under the contract, or whatever? One of the things, for example, I use Illinois, which is my home state. We have a 5-stage process for reopening Illinois. The last stage basically requires that there be a vaccine available. Leading up to that, stage 4 says that, yes, we'll allow meetings of up to 50 of gatherings. So if your meeting is 100, what assurance can the hotel give you, much less anybody give you, that within 6 months there'll be a vaccine which will allow you to go to current stage 5? My problem also is we're now seeing lawsuits being brought against governors and mayors saying and challenging their authority to impose these quarantines for various and sundry reasons. So we have so many balls up in the air right now as to how this is going to play out. You have the people challenging the rules restricting participation. We have the governors and the mayors enforcing the restrictions. We have a whole panora of bad things going on out there. So the key element here is we're in this together, as Josh said, and we see the logos. You got to work together, and you got to try to figure this out. You know, I'm a great campaigner, as many of you know, against win-win. My approach is partnership. And in a partnership, you share in risk and reward. Right now, ladies and gentlemen, we're sharing in a lot of risk. And so what we have to do is, how do we work to minimize the extent of that risk for both parties?
So before we go on, I do have a couple of questions that also relate to this, and I do apologize. I seem to have a Zoom bomber on my desk, so if you see ears, they're not mine. They belong to one of the cats that own our house. But let me say to all of our attendees that I am logging every one of your questions as they come in, and based upon the number of them that are coming in. So far, there are 41 of them. We may not get to all of them before the end of this session, but we will try to get all of those answered by John and Josh. The first question regarding rescheduling, and I'm kind of categorizing these as rescheduling, is what might happen if the postponed date approaches and the decision to postpone comes around a second time. In other words, you postponed, you've moved, and then you postpone again. Is there anything special about that?
Well, let me look at it this way. What does your revised contract provide? And what rights do you have for being able to maybe kick the can down the road one more time, or to get out of the meeting overall? In some situations where people were able to successfully cancel because of a force majeure, they're probably a little bit ahead of the game relative to rebooking. But for those who basically, in order to get around this, to share in that risk, went forward and managed to rebook the event. The rebooked event, depending on what your contract says, and what we have seen, unfortunately, in some cases, is you are so glad to get it rescheduled and postponed that you haven't really read the small print that basically says, well, maybe we won't let you off the hook. this time around. So you've got to, again, be careful of what that rebooking contract provides, or is it an amendment to the existing contract changing the dates? The other thing too, let's face it, are you really going to need as many sleeping rooms for the postponed event as you did for the current event? A lot of events for this year were based upon what your figures were for 2019. 2019 was a bumper year for everybody. Everybody moved their numbers up. Now, having said you're reducing your sleeping rooms, well, now with social distancing, are you going to need more meeting space so people can stay 6 feet apart? Are you going to have to limit the number of people who can go into a particular room? So the logistics really have made an absolute imperative need to reevaluate not only postponing it, but what is that postponed meeting going to look like?
Yeah, and I think that one of the mistakes that people made early on was that we're in this pattern of not allowing cancellation but crediting. Airlines are doing it, everybody's doing it, and there's a reason, because the vendors, the hotels and everyone else doesn't want to give money back. They want to keep the business, and that's somewhat understandable. But if I were rebooking now, I would have, as John alluded to, a contract amendment or an addendum that had terms that said that if we agree to move forward, but conditions are X, Y, and Z, so the meeting won't work, we can cancel even then, and/or we can have a reduced room block, and our deposits. You know, if you're rescheduling for a year from now, maybe the deposit schedule is pushed back, but there needs to be a real thought to what might happen if things can't go forward at the reschedule time. The other thing is, I wonder if we reschedule the first time based on COVID-19, can you declare a force majeure based on COVID-19 for the rescheduled meeting if conditions are still bad? Because we knew about COVID-19 when we rebooked, which normally, if you know about something, it's not a force majeure, properly a force majeure occurrence. So these are all open issues, but bottom line, and as John said, you need to think about this, not just sign new dates, but think about the terms and what will protect you and your clients for that reschedule date.
Let me make one more comment. For many of you, you have got pretty substantial deposits on hand with the hotel. The question I have and the concern I have is, with all of the hotels out there which are now closed, are they going to reopen? Are they going to be there when it's time to apply that deposit? Or are you standing in line at the bankruptcy to get your money back as an unsecured creditor? The deal we have here, and what I suggest, is with deposits, get it back. If you can't get it back, then put it into an escrow. It's some way that that money is protected, that if the meeting goes forward, the property or the venue or the vendor is going to get the benefit of the escrow. If that meeting doesn't go forward because the hotel, the vendor is out of business, then the escrow disperses that money back to you. Mm-hmm. So I think it's very important to look at it from the standpoint of getting the credit for the deposit, but also protecting the integrity of the deposit should something go afoul relative to the property.
So another question also about rescheduling meetings, and then we'll hopefully move on to another topic. How are you advising event professionals who are advising their clients to reschedule their meetings and the client does not or will not reschedule?
Well, if they don't want to reschedule, then it's a cancellation, and they need to look at the cancellation provisions of the contract. And we've, I think, already covered that. You may be able to make the case for a force majeure. You may not be able to make that case, but to negotiate, you can negotiate something with the hotels and other vendors. The one thing, sometimes people have bad force majeure clauses, and when I say bad, meaning they might only deal with cancellation because it's impossible to have the meeting. which arguably we've never been in that situation, although the government prohibitions could make it that. But even if you have a bad clause, if this were a marketing presentation, I would say that's when, if you have a good lawyer, you know there are other arguments that can be made. Since this isn't a marketing presentation, I'll just say there are other arguments that could be made. There are legal principles like frustration of purpose or commercial impracticability, which in many states apply even if you don't have a good force majeure clause. And without going into detail, they can give your client additional rights on cancellation. The challenge is it's unlikely a vendor is just going to turn over and refund your money. But if you've got some fortitude with your clients to fight, or if there's a win-win for the venue, as John was saying before, you might get some, you might be able to use those things to your advantage.
Two things I would add here. Number one is when you're rescheduling a meeting, you're going to have to be doing more work. And so maybe the fee that you had originally dealt with the first round. Now you have an entirely different round where you have to make new accommodations, you have to make new arrangements, you have to hire maybe additional people, new people, whatever. Does your contract with your client provide that in the event of rescheduling, you are entitled to additional compensation relative to that rescheduling and how that will take place and what you have to do in that regard? And secondly, in your contracts, you want to make sure that with that cancellation or that other provision, what's the cancellation requirements going to be? I think Josh made notice of notice as to what notice has to be given. In some situations, it may be very limited. And what is it with you and your client as to how that plays? And for your client, should there be a cancellation and there is non-refundable deposits, is the client going to be the one that is going to pay that non-refundable deposit, or are you going to be stuck with it? Again, looking at your contract with the client, not to mention the vendor, but how do you get compensated so that you're not out there basically funding the non-refundable deposit?
So a clarification on the question asked, the planner is recommending cancellation. The client says no. What does the planner do?
Well, the planner follows the desire of their client is. I think that's sort of the bottom line, is if your client says, hell no, I won't go, you don't have much choice. Again, though, what does your contract provide that should that happen, how do you get compensated? So you need to have a provision that should the client cancel for whatever reason, I don't care if it's force majeure or otherwise, but I would be also very careful that we have had some arguments coming back because I had to cancel because of a force majeure. I don't owe you, third party, anything. You have then basically given up all that compensation that you would have had. So you got to be careful what your force majeure clause says with the client so that you protect yourself for compensation for services that have been rendered.
Right. I would just add that when I work with third-party planners, I always recommend that that you have a management fee in addition to any commissions that might be there, but that you get paid substantial amounts of your management fee before the meeting, if not everything, at least as much, that so that you can pay yourself and your employees, and maybe you don't get your profit, but at least you're made whole in some respect before the meeting. I think in these times, that's even more important if you're able to do that.
Unfortunately, we're seeing arguments coming back from clients to third parties. Well, it's a force majeure. I don't owe you anything. I want my deposit money back, et cetera, et cetera. We've had a couple of these. We've had some very major ones, including incentive programs in particular, where this becomes a real problem based upon the failure of the client contract to address the issues of cancellation and what happens where a force majeure intervenes as to the reason.
Right, right.
So here's another question in regard to third-party payments. What are some cancellation clauses to ensure a solopreneur, a new title, I guess, gets payment for holding dates on calendar when an event gets canceled. For example, flat cancellation fee, percentage of project value. And I'm guessing you're going to say there's something that has to be in the contract before it happens. Is that not true?
Well, sure. I mean, you know, historically, I think third-party planners were not, may not have been appreciated for the value they brought to a meeting and the services they're performing, because you may have been paid wholly or largely on commissions. And since the clients may not have been paying out the money, they may not recognize how much work goes into it before the meeting happens. This is why you need to make it clear in your contract that there's a management fee. You can call it whatever you want, but that's essentially what it is. And that to the extent you've performed services before the meeting, and I would argue if the meeting is canceled for any reason other than your own fault, meaning the planner's own fault, you ought to get paid. And if you put that in the contract, and by the way, I suggest to third-party planners, you get paid even if there's a force majeure. And in most cases, the clients tend to agree with that. The point is that you have it in your contract, so you have to get paid, and you set up a deposit schedule so that you're compensated again before the meeting adequately, so that if the meeting is called off for one reason or another, you're still paid. The other thing, and I'll just say this quickly, is a mistake a lot of us make, and not just planners, but anyone who deals with having to get business from other people, is starting work and providing value before you have a contract signed. Even before COVID-19, I've gotten a number of calls from clients or prospective clients in the last year or so that say, I'm working with XYZ big company, and I've been working with them for 15 years, and they've always called me and said, we're doing our annual meeting, and please start the work, set up the speakers, set up the venue, do the site visits and all that. And then a new CEO comes in and cancels everything. And all of a sudden, this company you've worked with for 15 years says, we don't owe you anything because we didn't have a statement of work for this meeting, or we didn't have an MSA in place. So important to protect yourself. It's a little sensitive, I understand, but at least create a writing, a letter, an email. A letter is better. Send it to the client and say, at your direction, I'm starting work, and we understand, of course, that I'm going to be compensated for my efforts, and we intend to sign a contract, but I'm starting work at your direction. And so you've created a record that you should be paid even if the meeting's canceled and you have no contract.
And Josh states it well. I think the other thing too is too much of the old business model has been based upon not an agreement with your client, but an agreement with the service provider that you'll be paid a commission or a placement fee or something of a similar nature. Well, you're going to live and die on the basis of what you put in those contracts. And when it's only a two-party deal where you are not even a party to the contract, such as in a hotel contract where the hotel will pay you a commission or a placement fee, and then that program doesn't go forward, well, I'm sorry, you're not going to be compensated. And the business model that needs to be in place today is just as Josh suggested. It's a fee for service. Now, you may want to put in there that offsetting that fee would be a percentage of the commission or the placement fee that would be paid. But if that isn't paid, you still want to be compensated.
So I want to do a time check here. We are at 8:45. We maybe have answered a fourth of our questions thus far, which says we have some very interested people who want to know a lot of things. And I just want to do a time check with Joy and Sarah. Can we go straight to 9 a.m.? Let's see if I can get an answer here.
Yeah, sure.
Go ahead. Thank you, Joy. Appreciate that. We also had a response from one of our attendees who said within his contract's cancellation clause, he has a delay to fruition along with a cancellation fee. you guys think about that?
It's a nice name.
I'm not quite sure I understand what it
Yeah.
is.
If that means that if there's a delay, then he gets paid something extra to account for the delay, since there may be additional effort required in postponing a meeting. I think that's certainly something that's legitimate.
I do too. And as I mentioned earlier, it's important that you provide that should there be a delay or should there be a change in dates where additional work is going to be required, you ought to be compensated for it. And so you want to have your contract provide, hey, I'm going to get compensated for the delay, whether it's your fault, the hotel's fault, or nobody's fault. If there's a delay, I still am entitled to my compensation for the services I render up until the time of completion, and so on. So I think it's a key element. One of the other, I'll go back a little bit here. One thing that's back to the hotel contracts, where you have a commission provision in the contract, is the big question that comes about so many times is, when is that commission earned? And we're seeing situations where maybe your client decides it's time to dump it, to go to Uncle Joe and have Uncle Joe take on that responsibility. And well, my argument and my position has been, if you're named the contract with the hotel, at the time that contract is signed by the customer, you've earned your commission. The question is, how much is that commission going to be? That is then delayed until the time of completion. So the big argument here is making sure it states very clearly that that commission is earned upon the execution of the contract.
So another question on force majeure, and I think it's probably one that we don't have enough time to answer in the remaining time, is how will force majeure change moving forward?
Well, it's an interesting one. And, you know, I just happen to have a few pointers here. I think that just a few things that we would look for, and I'm going to try and talk quickly, because you're right, this could be a comprehensive conversation. Here's some of the things that I would look for incorporating in a new force majeure clause. We have every force majeure clause talks about cancellation for government regulation. Well, we don't know exactly what government regulation you mean. Is it which level of government? Is it federal, state, local government? Is it all of them? Which I would argue it ought to be any government regulation with applicability over the venue location, but also if most of your members, or a good portion of them, like 25%, come from a particular area, one area, then maybe government regulation ought to apply where they're from as well, because it's a significant number of attendees. Also, is it a government law, statute, order, advisory, recommendation? Again, I would argue all of the above. Remember, people love to look at the CDC. CDC doesn't issue orders. They issue recommendations and advisories. If you want those to apply, you need to say that to make sure they're included. World Health Organization is a governmental body. Is that included? Another thing that I would look for is, we discussed before about timing and all sorts of things like that. When can you say it becomes commercially impracticable to perform? Is there a time we can agree? Is it the cutoff date? Is it, as John said earlier, 3 months before the event? There ought to be some sense of it. Another thing I would look for, I discussed before, asking the property to provide evidence that it can perform. Now, it is unlikely that a property is going to tell you, we can't perform a meeting in August at this point. But if you could put in your clause something that says that you have the right to demand that the venue provide evidence that it will be able to perform fully under the contract. And I mean fully, all the amenities and services that you have in your contract. And if you request it within, let's say, 90 days of the meeting, they need to provide that to you in writing within 5 business days, let's say. That's something else you can put in. So I'm going to stop there. That's just some of the things that I would add in because I know that John has some things to say, but there's a number. It's really a rethinking of how these clauses, how they would work. Do they work for you? And if not, how should they work under COVID-19? And that's what needs to be in the clause. John, go ahead.
I'd like to go back a little bit here to what is the force majeure clause. Even if you didn't have a force majeure clause in your contract, the common law would say that if performance is made impossible as a result of the action of neither party, then you're excused from performance. A hotel burns to the ground, they're excused from performance. So what I like to do is sort of separate out what we would traditionally call a force majeure clause to additional clauses which detail specifically what allows you to cancel or renegotiate without liability. And many of these things that we've been talking about would fall more in that latter category than in the former category of being a pure force majeure. As Josh indicated, for example, if you got a meeting of 200 people in Florida in December and you've got 40 people coming from Fargo, North Dakota, there's a good possibility those 40 will not be able to make it because of the weather. So rather than cancel the whole event for 160 other people, wouldn't it be better to reduce your liability by the 40 people who cannot get there? So looking at the demographics of your group, looking at the timing of your group, what are the things that are going to impact upon your attendance, your ability to perform and to have a successful event? And those are the things that fall within that category. What would allow us to renegotiate or to cancel because beyond just pure force majeure. Josh made the comment, say for that meeting coming up in December. Well, what if we have son of COVID or daughter of COVID, which is a different deal? What if we have a different kind of pandemic that comes about? This is sort of the 100-year anniversary of the last pandemic, which was a Spanish flu. We've had a number of health incidents which have not quite reached the stage of being a pandemic, but they have in some areas reached a state of pandemic. The AIDS and HIV problem in Africa was a pandemic in Africa. SARS and the Zika, but those were limited in no small part to specific geographic areas, but they still had an impact on the ability of people to get there, participate. And remember also that fear is not an excuse for people not coming. And that becomes a real problem when we're dealing with post-pandemic type of situation. We've had a number of situations with, let's say, Legionnaire's disease, where people know that that hotel had Legionnaire's disease. They still want to go maybe to that town, but they sure don't want to stay at that hotel. And so you have a lot of things based upon fear, which may be limited to a particular incident or opportunity. So we've got to adjust what are the things that are going to excuse performance and allow us to escape without liability versus those things which the law may allow us to get away with even without a clause. So I recommend taking Josh's examples, which are excellent, and putting them into what is going to excuse performance, and then what happens when that performance is excused.
Right. May I just add, and I'll be quick, I promise. I've actually, in addition to a force majeure clause, formulated what I call a COVID-19 clause for meetings in the next 18 months to 2 years or so that specifically address conditions, the adaptations with COVID-19, that if we have relapses of COVID-19, another wave, that specifically allow cancellation on that basis, in addition to the regular force majeure. So go ahead, I'm sorry, just wanted to mention that.
No, I just had a different question to ask on the topic. I think those are very good answers for everyone on when to pull the trigger. If you look at cancellation on a weighted scale, where there's a tipping point to where it favors the venue or the organization, the group or organizer, what if the states all open right away, but your group wants to use force majeure to cancel? Does the state's opening have any effect on whether you can cancel the meeting under force majeure.
Well, if
What are
the
the terms
state,
of the opening?
yeah, if the state's closed, it's certainly helpful for force majeure, but you're right. What are the terms of the reopening? Uh, Are there group gatherings permitted without limit? Are there group gatherings permitted with a certain size? Inside a venue, is there still mandatory social distancing? Which I think we'll see for the time being, even in most open states. But your force majeure, to me, there's strict force majeure, as John was talking about, and then there's sort of the meeting industry force majeure, which from a planner's viewpoint is not, can we literally have the meeting? That's not the end of the discussion. It's, are our attendees going to show up at the meeting? Will they come? And I think for planners, the key is to try and negotiate a clause that answers that question as much as, can they literally have the meeting? So even in that circumstance, even if the state opens up, again, it doesn't help if you're determined to cancel, but it's not the end of the conversation by any means.
Now, again, it goes back to know your group, know what's going to be required, know the understanding that even if the state reopens, that they are going to have limitations on what has to take place in order to meet the requirements of opening. As I said, in Illinois, until they have a vaccine or there is a basic fundamental understanding that the disease is under control, no group over 50 is going to be allowed. And even then, you're still going to have social distancing and maybe some other requirements that are put in play. So just saying the state is now open doesn't mean squat until you understand what the whole concerns and what the limitations are for that state to be open, or that community for that matter.
And to add to that, I'd have to say that in California, we have some pretty strict regulations that come from our governor. In the county I live in, I'm not allowed to move outside the county. So, that further complicates it because my county is doing well and it doesn't want it to change. So I think it's that complicates matters in the various states as well, does it not?
Yes.
One of the things too you look at is, for example, being from Chicago, for a lot of states, a lot of places, if I go to that state, I've got a 14-day quarantine that I have to honor when I show up in that state. So as much as I might love a particular venue, do I really want to be stuck there for a 2-day meeting for an additional 12?
Right. I would just also caution that as responsible professionals in the meeting industry, it's important not to ignore the rules that are still in place. Many of us are facing situations in our states where some people want to open the state up more than the governing authority, the governor or whoever, would like it to be opened up. And sometimes there are businesses that open up more than is actually permitted because they can get away with it or there isn't enforcement. My sense is that if you stretch what's permitted or allow your clients to, I'm not suggesting you're responsible if your client does something, but the point is, it for liability purposes, stay within whatever the law is. That's important.
Any closing comments from you, John or Josh?
I'll say that the one thing that we have to bear in mind through this whole thing, there's a legal aspect, there's a pragmatic and a practical aspect. And from a pragmatic and practical standpoint, the number one concern that we have to have is what is in the best welfare and interest of the people who are going to be attending our meeting, what's in the best welfare and protection of the people who are going to be responsible for providing service to our group.
So I go ahead, Josh, and then I have a couple of closing comments.
Yeah, no, I just want to say really quick, I think what's become apparent from this conversation is that we're moving through such a period of uncertainty that as business returns, which I believe that it will. Maybe some baby steps at first through regional meetings and things where people can drive rather than having to get on an airplane, but that's where I'll start. But as we get back to business, planners that have experience and knowledge and are familiar with the new reality are going to do well. And along with that, planners that are able to demonstrate their value to their clients and charge for that value will be the ones who do okay through this as we move on into the future.